Hey, Nate Webb from the Webb Law Firm here, www.webbattorney.com. That's with two B's. I'm here to talk to you today about driver's license hearings or Department of Licensing administrative hearings. So if you found yourself arrested for a DUI in Washington State, much like many other states, there is a separate hearing. It's usually done telephonically. Here in Washington State, it's pretty much always done telephonically regarding the uphold of your suspension. So initially, if it's a first offense DUI and you've been arrested and you took a breath test, your license suspension is going to be for 90 days. That suspension would start 30 days from the date of the arrest. However, you're given 7 days from the date of the arrest, and you should be provided this documentation by the arresting officer to let you know that you do have that 7-day period in which to request a hearing, a telephonic hearing with the Department of Licensing to challenge that suspension of that 90 days. Okay. If you did not take a breath test, if you refused, then the license suspension would be for 1 year for a first offense. But you're still given that 7-day period in which to request a hearing with the Department of Licensing to challenge that suspension. In that type of hearing, there are certain rules that the administrative law judge is going to abide by, and I'll put them here. Here's the Washington Administrative Code link for those rules so you can look at them. The rules of evidence are probably a little bit more lax in that type of hearing, but you are allowed to admit evidence. You're allowed to admit exhibits. You're allowed to subpoena the officer should you choose and have them testify at that hearing. You're also allowed to present any video evidence, photographs, whatever you'd like to present for consideration by the administrative law judge. The caveat here is that in an administrative law hearing regarding your license, the burden of proof is much lower than it would be in a criminal matter. And so since this is a civil matter regarding your driver's license, not your liberty going to jail, it just has to do with your driver's license, then the burden of proof is by a preponderance of the evidence. And that's a civil burden of proof. And what that means is, as I tell juries all the time, that just means it's more likely than not, or it's slightly higher than a 50% burden. Okay, so it's 50.1% burden. So they have to establish 4 things in that hearing in which to uphold the suspension of your driver's license. The first thing in that hearing they have to establish, and this is typically the officer submits just a written report. Any other evidence is usually provided by your defense attorney if they want to provide it. Sometimes we provide the video evidence, sometimes we don't, because obviously sometimes it's helpful, sometimes it's not. But the hearing officer, or used to be hearing officer, administrative law judge, does not get any video evidence from the officer or trooper, whoever might have provided that to them. So any of that type of evidence is provided by your defense attorney. So there's 4 things they're establishing in that hearing or trying to uphold. Was there a reasonable basis to stop you? Reasonable basis to conclude that the petitioner, you, were driving under the influence of any intoxicating liquor or any other drug, marijuana, for example. So that means, was there a valid basis? Was there a traffic stop? Was there an accident? Some reason that the officer had to make contact with you under the law. Okay, so it has to be a valid, reasonable suspicion. Reasonable suspicion is one of the lowest burdens that we have, so it doesn't take much. Okay, and again, all in the concept of by preponderance of the evidence. So all 4 of these things only have to be established by that preponderance of the evidence burden. The second thing they have to establish is, was there a lawful arrest? And so that means, was there probable cause? Again, another low burden. So there's reasonable suspicion, there's probable cause, and then we go up the ladder from there. But probable cause to arrest you. So typically that's the observations made by the officer of your speech or your face, your eyes, but more importantly, if you did field sobriety test, which I don't recommend, what the results of those were. And so again, by only a preponderance of the evidence standard, did they have reasonable suspicion and to stop you, lawful arrest. The third thing they have to establish by preponderance of the evidence is whether or not the officer informed you of your right to take the test or not. And that's typically by what are called the implied consent warnings for breath or blood. And so in that document that you're usually read at the station prior to the administration of the test, you're told that if you are refusing this test, you're going to lose a license for a year. If you take it and you're over 21 and you're over 0.08, you'll lose it for 90 days. But that you do have the right to refuse the test. But again, if you refuse it, there is a sanction of a year. You also are told in that document that you have the right to an independent test of your own choosing, which I always recommend that you ask for. So if you're ever arrested and you agree to take the breath test, which you probably should want to do, then you'd want to ask for your own independent blood draw. So that means that not their phlebotomist, but someone else. You can go, they need to make arrangements to take you to the hospital to have a nurse or someone take it so that you have your own independent test to be verified and tested by your defense attorney should they choose to do. The last thing they have to establish is whether or not the test that was utilized to procure your reading, whether that be breath or blood, was done according to state protocol, state toxicologist protocol. And so, did they set up the test, the Draeger Alcotest machine correctly, and did they follow the procedure? Did they use 2 mouthpieces? Did they make sure the tube was warm to the touch? Did they observe you for 15 minutes after they checked your mouth? So there's different things like that. So when I say check your mouth, they don't have to actually look in there with a flashlight, although that's the best procedure. They just have to inquire as to whether or not you have anything in your mouth. And so then they have to wait 15 minutes before they administer that test. So those 4 things they have to establish only by a slightly higher than 50% standard. So it's a very difficult hearing to win. And most of the time, unfortunately, you're not going to win. But you're not going to win if you don't ask for the hearing. And so I typically advise my client to ask for the hearing because I have over the years seen many instances where there might be some documents missing or something like that, or we might subpoena an officer or a trooper and they fail to appear. And so there's a case that says if they fail to appear, other than in a commercial driver's license hearing, that you can move to dismiss that case for a lack of due process, basically a lack to confront the witness against you. And so that's Lytle versus DOL. And so that's an old case that's been around for a while that all attorneys know about. But those are the 4 things that have to be established in that type of hearing. And so if you find yourself charged with the DUI and you're not yet sure what to do about that hearing, remember, you only have 7 days to ask for that hearing. And I always tell my clients too, you can ask for this hearing online. They provide you just with the document, and so you don't necessarily have to send it the old snail mail fashion way through the post office. You can ask for it online through your License Express account, or you can take that document and it actually tells you on there you can fax it or email it to the Department of Licensing to ensure that you've asked for the hearing. There is a fee in Washington State to request that hearing. It's $375. When I started back in the day, it was $100, but now it's $375 to request that hearing. That's not the attorney's fees, that's to the Department of Licensing. And so it may sound not very fair that you're having to defend yourself and prove your innocence, essentially, but that's just the way our system works here in this civil context. And so if you find yourself charged with a DUI and you are wondering what to do about this piece of paper that you got called Request for DUI Hearing, here it is, then you'll want to give me a call and we can talk about where to go from there. Again, Nate Webb from the Webb Law Firm, and if you have any further questions, feel free to comment below, or I always do put my information down below. All right, guys, take care.